Okay. We have a jury deliberating, so we will have to interrupt what we're doing if anything comes back from the jury, although I don't see the defense team, but I've got their phone number. Do you?
Mr. Hurst said he was just outside.
Okay, great. They can stay there. We've got a pretty quick calendar for this afternoon, so maybe we'll be able to catch up for the time I made you all late. Position 1 is State versus Beck. Is Mr. Beck here? Is there a lawyer for Mr. Beck here? That would be Scott Smith or his colleague. All right, Ms. Nix, there was a lawyer for Mr. Beck here a few days ago, maybe a week, it was last week. I think he had his wires crossed as to when that would be. He reported, I think it was Mr. Majeski, but name doesn't matter. It was a colleague of Mr. Smith's and was here on behalf of Beck. And the storyline was that Mr. Beck was in Maine with a broken leg. He's not here, he's not zoomed in, and now there's not even a lawyer here for Mr. Beck. So my thought is bench warrant on all his cases.
Yes, sir. And it wasn't Mr. Majeski, I can't remember which of Mr. Smith's colleagues it was here, but I was never provided any proof of this medical issue in Maine, and we held off on issuing a bench warrant the last time because he had this court date today. So
right.
I would move for a bench warrant or support you issuing a bench warrant, sua sponte, whatever.
All right. I will have your team and Ms. Nelson work together and whatever we do with bench warrants so that we get them in each of Mr. Beck's 3 cases. Done. How about Ryan Howell?
Judge, he's in custody. This is actually Ms. Cabrera's case. She's in Douglas on a murder right now.
Uh-oh.
I've conveyed to Mr. Howell that she'll be out to see him as soon as possible, so he knows what to expect.
Okay. And this is Mr. Howell? Great. Hey, Mr. Howell, how are you doing?
Yes, sir.
How are you?
I'm doing all right, sir.
Good. What do you got with you?
My paperwork and my sandwich, sir.
Your sandwich. Don't lose that. Don't lose that. Mr. Howell, your lawyer, Ms. Cabrera, is in the middle of a trial right now. You probably heard what Ms. Wood said, and she may even have told you back there.
Yes, sir.
She's a great lawyer, but she can only be in one place at one time.
Yes,
and
sir.
Trial comes before the conversation we were going to have. So Ms. Cabrera will be freed up soon from that trial in that other jurisdiction. She'll connect with you, and then she will reach out to my staff. And Ms. Nix, is this your case or would this be a Willingham case?
This is my case.
Okay. Ms. Cabrera will also talk with Ms. Nix. What's the posture of the case in terms of, has there been an arraignment? I'm not in Odyssey yet, but I can get in there.
I looked at it earlier today, and I believe that well,
I know one thing that happened is that we lost track of Mr. Howell because at one point there was a failure to appear, and that's certainly something we'll talk about with Ms. Cabrera to address that. But we also need to make sure that your case is moving along. So I'm pulling it up right now. Go Odyssey.
it looks like he may have appeared, this used to be assigned to Judge Carnesel, and it was
How did it get here?
P&A twice before discovery was filed, and then on the most recent P&A in December of 2023, that's when he failed to appear, after it had already been assigned to you.
Judge, I think it got assigned here because I had the co-defendant who was the brother who has already pled.
That's Brian?
Yes, Judge.
Got it. But in a different, it lists him as a co-defendant, but then maybe Brian Howell had another case as well?
Or something.
Okay.
I don't remember what happened.
Got it. Yes.
Yeah.
Well, you know what it says here? This is interesting. What got transferred is it says Ryan Howell, also known as Brian Howell. And so I'm going to let you talk as long as we're not talking about the substance of your case.
Yes, sir.
That this Mr. Howell, and are you Ryan or Brian?
Ryan Howell.
Ryan with an R.
Uh-huh.
Okay. That Judge Carnesel mistakenly believed that Ryan was Brian, And so this case may go back to Judge Carnesale where it rightly belongs. But we're going to talk a little bit, not about the facts of your case, only about, do you have a brother named Brian Howell?
Yes, I had used his alias name though.
Okay.
And some of his record, when I say this, some of his record is some of mine, and some of mine is on his. That's what I was trying to tell the last time I came.
Got it.
Before you though.
Does your brother sometimes use your name?
No, sir.
No, you use his name.
Yes, sir.
So you have, okay, I don't want to go further than that, but
Yes, sir.
but it's not that, so it may well be that the Brian Howell that we dealt with, and there it is, Ms. Wood's case, I was the judge, and there was a plea in November of 2023. Was that you?
Well, that's my twin brother, Brian Howell. He's on probation.
Yeah, I'm looking at him. He does look like you.
Yeah, he's my
but-
twin. I'm identical twin.
Okay.
So
That's super confusing, and your parents should have named you Fred and Dwayne or something instead of Ryan and Brian.
yeah.
Those parents. Okay. What are the last four of your social?
258 4559.
4559. Okay. And your brother,
58
pardon me?
258 45 69 58. 258 45 69 58.
6958.
That's my social.
That's your social.
And date of birth is 05/12/73.
Yeah, but you and your brother are gonna have the same date of birth, so that's not gonna help us. How about your address?
5152 Jamaica Court.
Does your brother live where you live?
No, but he used that address.
Okay. I assume there's some way to say they're like different fingerprints. I don't know where to look in Odyssey.
Yes, we got different fingerprints, Your Honor.
I believe that.
I can answer that.
Yep. Okay. Thank you. So one, we need to get Ms. Cabrera, the lawyer, to engage with you so we can figure out what we're doing with your case.
Mhm.
Two, I need to do a little homework, and it's going to involve looking at the fingerprint numbers that are in the system to see if the case that Ms. Wood had in here where someone, you or your twin, pled guilty in November of last year, if that was you or if that was your twin brother, Brian.
What was the case about, Your Honor? And I can go and tell you, and I can give you the decision on that one.
Sure. So the charge was having a gun. It was
Yes, I can give you an answer on that. That's Brian Howell, Brian C. Clifton Howell.
Okay, your brother.
Yes, my twin brother.
Okay. All right.
His middle name is Clifton, and his first name is Bryan, Bryon. Last name is Howell, Howell.
Okay. Thank you. I appreciate that. How long have you been in jail?
30 days, sir.
Okay. Well, we're going to focus on resolving your case. It may mean that it goes back to the judge who had it originally, but either way, we'll get a lawyer in touch with you and get it moving, okay?
Okay. How soon is that going to be? So not trying to speed it up or nothing like
No,
that.
well, you should try to speed it up. There's nothing wrong with that.
Just asking.
Yep, it's a fair question. We'll figure out today whether the case stays here or it goes to Judge Carnesale. That's the best answer I can give you. If it stays here, then we'll figure out how Ms. Cabrera can get to you. I mean, she needs to finish her trial. And then, are you at the county jail?
At the county jail, yes, sir.
She knows how to get there, and she'll meet
Okay.
with you. She'll talk with the prosecutor and make sure she's got discovery. And we'll do that. If it's going back to that other judge, then she'll see you soon and can give you her sense of the deadlines. Okay?
Okay. Could I have a number?
Whose number?
My lawyer.
Yes, we'll
Yes,
get that for you.
Yes, I do not have it. So-
Okay. I will get it and we'll write it on a card and you will leave with that.
Yes, sir. Thank you.
You bet. Why don't you go eat that sandwich? And before they take you down, they'll get you that card.
Yes, sir.
Thank you.
Thank you.
So how do we do the finger? I don't mean he needs to be fingerprinted again, but shouldn't his booking record, we could compare that with the booking record for the case Ms. Wood had? Okay, and they'll say it's fingerprints 1, 2, 3, 4, and 5, 6, 7, 8. Those aren't the same people. Or it is the same person, in which case he's a little bit of a rascal. Okay. Thank you, Ms. Wood.
Thank you, Judge.
Malcolm Baldwin.
Judge, I think I saw a waiver and I think Paul Howard is on this case.
Yes, and Mr. Howard,
The Paul Howard?
yes, sir, emailed me this morning asking to be excused, and I said, you need to ask Ms. Nelson about that, so,
Interessant. All right, let me look that up. In fact, it is. That's the lawyer. So, whoops, come back. There was an entry of appearance, something called Baldwin Consolidated Motions. Oh, because that's this guy's last name. Okay. I don't see a waiver, but Attorney Howard told you he had filed one.
I think he just spoke like, I think he just said that he was going to waive.
Okay,
And he said, we would like to waive arraignment and enter a plea of not guilty.
I'll have Ms. Nelson reach out to him and he can execute one of those forms. His client is on bond, has been for 2 years now. This was a bond from June 2022. Hope he doesn't have an ankle monitor. Oh, needs to stay away from someone. Okay. Because of that outreach, do you have any issue with handling it that way? Or I don't think we formally excused Mr. Baldwin. I suspect his lawyer told him he didn't need to be here. But there is a lawyer of record. There is the entry filed and his consolidated motions, which you're not supposed to file. Like this big omnibus thing. We're off to a good start.
Yes, I'm fine with holding off on a bench warrant until we at least get contact with Mr. Howard.
Okay. Look who's here. Thank you. That's the number for Ms. Cabrera?
Yes.
Thank you. Nope. Once he's got that, I don't mean a sandwich. But, oh, I thought you needed a fingerprinted. No. He can go. And the case will stay with me if it's the same fingerprints, and we'll bounce it to Carnesale if it's not. All right, let's see if we can get someone who's here. Ms. Stroud shouldn't be here. You filed a waiver and we cleared it, but just in case, is Ms. Stroud here? How about Maddie Brown? Hi, Ms. Brown.
Hi.
How about Dontius Brown? Also excused.
He's mine, yes, Judge.
Okay, you represent Mr. Brown. Ms. Brown, is Dontius, am I saying that first name correctly? Is he related to you? Your son, okay. Your son is represented by Ms. Wood, which means her office, her firm cannot also represent you. Do you need a lawyer appointed to represent you, or were you planning on hiring one?
I guess I would like to have a warrant.
Okay, that will probably be the infamous Ms. Cabrera that I've been talking about, who's handling a murder right now in Douglas County. She handles what we call a conflict situations, where there are two defendants And if Ms. Wood's office has one, we have to get an independent lawyer to represent the other, and that would be Ms. Cabrera. She can't be here today, so we'll need to get you to come back. I want to make sure we've got good contact info for you, and I'm sorry we couldn't get Ms. Cabrera here today, but she's stuck in court.
I didn't receive a letter.
Well, it could be lots of explanations for that. Yeah, one is that you got arrested almost 2 years ago. So Ms. Brown, that's not the button I meant. I've got an address for you. I've never heard of this road before. Catherwood Drive, Catherwood, but that's with a K.
Yes,
Okay, 1004.
yes.
Okay, so that's the address. That's where mail goes. If you still, there's no apartment number or anything?
My son, his letter came, but I never showed up.
Interesting. You and your son live in the same house?
No,
No. Did his letter come to your address?
yes,
So his mail got sent to the Catherwood address?
yes.
All right. Well, it's what we've got for you, 30310. We'll keep sending things there. But does your number end in 8889?
Yes, sir.
All right, we've also got a good phone number. So Ms. Cabrera, assuming she is appointed to represent you, she's got a phone number she could call and reach out to you about your case. I don't have a new date to give you. I'll be talking with my staff about when we'll get you back here. But I'll want to wait until Ms. Cabrera says, yes, I've got this case, so we don't waste your time and bring you back here only to say, we still don't have a lawyer. Okay? Is there any information you want to get, Ms. Wood, from Ms. Brown? I know you don't represent her, but just to close the loop?
Yes, I'll get it and I'll give her Ms. Cabrera's number and I'll also get her information from Ms.
Great. If you don't mind giving Ms. Wood, and again, this is your son's lawyer, but all she's going to do is share your contact information with Ms. Cabrera so the two of you can connect.
Thank you.
All right. Thank you. All right, so Dantius Brown has been handled. How about Dante Edwards? Hey, Mr. Edwards. I'm doing all right. Your lawyer is here virtually. If you don't mind coming up to the podium, just that way you can see her and she can see you. Let's do this and then add the podium. There we go. All right, that's Ms. Rios. You see her on the screen?
Mhm.
All right, and you are Mr. Edwards.
Yes, sir.
Ms. Rios, Mr. Edwards is here for plea and arraignment. What are we doing in his case?
I already just filed the waivers. We just need the scheduling order.
All right, so have you spoken with Ms. Rios?
Nah, I received the email. Well, actually, the bonding company had called me and told me that I had a court date, but never gave me the information. And then I received the email this morning. I'm probably like 2-3 days. I just checked it. And then that's when I had called her this morning, where I found out that I had to go to court.
Got it. You don't check your email every day?
No, sir.
Okay, you may want to now that you've got this
Yeah.
case, because that's one of the ways Ms. Rios is going to stay in touch with you. I mean, she can text or phone based on what you two arrange, but
Uh-huh.
if it's something that's got a lot of words, it may be an email she sends you. So you may want to be checking that. But I guess she could always send you a text saying, hey, check your email.
Right.
I want to see what we've got for your Did you get anything in the mail telling you to be here?
No.
Okay. So your charges aren't real old. The address in the system that generates letters that go out says Hendricks Avenue,
Yes, sir.
219.
Yes, sir.
Is there an apartment or it's just
No, it's
plain
a
old
house.
219? All right, well, that's where stuff goes. So you should get things in the mail, but your safety net is Ms. Rios. She will be letting you know when there is court next in your case. So whatever your phone number is or your however you communicate with people, make sure she's got that. So it is not hard for her to find you. Okay.
Okay, I just sent her my address and I'm gonna get her my phone number where she texts me from.
Good.
Text me on my.
Good. We'll give her all that stuff. Ms. Rios, anything else in Mr. Edwards's case?
No, Your Honor.
All right. Ms. Nix, anything in the case?
Yes, sir.
So what's going to happen next, Mr. Edwards, is that Ms. Nix, the prosecutor, is going to give all the discovery that she has. So that would be police reports, or given your charges, there could be a crime lab report where they weigh the stuff and test it. She'll get all that to Ms. Rios. Ms. Rios will want to talk to you about it, to give you her sense of, wow, there's no evidence here. We should take this to trial. Or, uh-oh, you're caught on tape with 100 pounds of whatever it is. You need to work this out. I mean, she'll give you her professional judgment, and we'll go forward. If it's a plea, we'll take the plea. If it's a trial, we'll do the trial. And there may be motions. There may be concerns that Ms. Rios has about how the drugs were found. Maybe she's going to challenge the search. I don't know anything about the case. She'll learn about it when she gets that discovery. She'll let you know what the plan is. And then your obligation is to show up whenever we've got court.
Yes, sir.
Any questions?
No, sir.
Okay. Ms. Rios, anything else?
No, Your Honor. Thank you.
All right. We will get the scheduling order out. Mr. Edwards, you're free to go. And Ms. Rios, you did a waiver on Mr. Kinney. Is Kwamel Kinney here?
He's there.
Mr. Kinney's here. Come on up to the podium, Mr. Kinney, just since we got Ms. Rios here. My notes from discussing this with Ms. Nelson, Ms. Rios, is say that you did file a waiver of arraignment. Is that correct?
Yes.
Okay. Mr. Kinney, your lawyer is the woman you see on the screen there. Have you two spoken before?
Yes, sir.
Great. Does she have all your contact information?
Yes, sir.
Do you have her contact information?
Yes, sir.
Good. The address we've got for you is an apartment on Southampton Road.
Yes, sir.
Still good?
Yes, sir.
Okay. I-7 or is it 17?
It's I8.
I-8.
Yes, sir.
Okay. Ms. Rios, if you could do a change of address when you get a chance for Mr. Kinney, what's in the system is I-7.
Okay.
And so it may be that they get it right because that's the neighbor,
We
but
switched the unit.
oh, you just moved?
Yeah, we switched the unit.
One door over?
Yeah.
Why?
It's bigger.
Oh, it's bigger. I was going to say that's a hassle, but you got more space. Okay. Well, we need to update that. So Ms. Rios, if you would update the address to I-8, that would be good.
Yes.
All right. Anything else, Ms. Rios, on behalf of Mr. Kinney?
No, Your Honor. Thank you.
Ms. Nix?
Yes, sir.
All right. Well, you heard what I said to Mr. Edwards. Same deal. Your lawyer's going to get discovery. You guys will talk about it, figure out where we're going next.
All right.
Any questions?
No, sir.
All right. You're free to go.
All right. Thank you.
Sure.
Thank you.
Judge, I have 2 off-calendar matters.
Yes, I just saw an email that says walk-ins, but I haven't had a chance to read it. But we've got time. Let me write down one thing.
Yes, like last week. This one's from May 28th, I think.
Not have their stuff.
Um,
Let's see.
and the-
All right, one of those names I recognize. So is it LaFavor?
Yes, Judge. Mr. Locke. It's very good.
He'll rejoin us in just a moment. Hey, are you Mr. LaFavor? Great, come on up, please. How do you say your first name? Cute, that's what I would have guessed, but I didn't want to get that wrong. All right, so, and last name, is it LaFavor or, okay, Mr. LaFavor, you were supposed to be here about a week ago, a little more than a week ago, for plea and arraignment. You weren't, so I signed a warrant, but I always tell your lawyer, the lawyer who's handling your case, if there was some miscommunication, or given your case where this is, wow, it's 2 years old today. You were booked in 2 years ago today. And people move, addresses change. So we're going to talk real briefly about why you missed court. And if there is an adequate explanation for that, then I'll set aside the warrant. If I don't buy your story, then you're going to need to go into custody because you didn't come to court for a date. In theory, you got notice for, but that's what we're going to talk about is really, did you have any way of knowing there was court? And it is not your lawyer's fault, meaning it's not that she knew and didn't call you. It's usually, Judge, I don't have good contact information. I had a phone number, I called it, and it's out of service. So it's another way of saying is that Ms. Wood did try to reach you, but whatever the contact information from 2 years ago, it didn't work for her. So Ms. Wood, tell me about Mr. LaFavor.
Yes, Judge. So I believe the address is still current, but we can confirm that. He did receive the letter. He said it just came like a day or two after.
We have that issue too with the Postal Service.
I was going to say, I believe that given the current state of the USPS, Judge.
Right.
And I also did not have a good number for him. The previous attorney for my office, for whatever reason, only got an email address for him. So I don't know if he even uses that anymore. I've gotten a good contact number for him now. He has my number. I think we're good to go. I would ask that you set aside the bench warrant. I did fill out a waiver of arraignment so we can just keep this case moving.
Okay.
If the court's inclined to lift the bench warrant.
So are you at, do you pronounce it Cairo or Cairo?
I pronounce it Cairo.
Okay, I do too, like the capital of Egypt.
Right.
But some in our state here say Cairo, but
Correct.
it's your street, so Cairo it is.
Yes,
You're
sir.
at 415 Cairo?
Yes, sir.
All right. We're going to keep sending things there, and one hopes that the Postal Service could get a letter from here, a couple zip codes away, within 9 days, because it's usually 10 days notice.
Yes.
Better yet, you now have a lawyer who's going to call you and email you and text you when you next need to be in court. Okay?
Yes, sir.
All right. Ms. Nix, it looks like to me this was an inadvertent failure to appear by Mr. LaFavor, but you may have information to the contrary. Anything you want to add?
Judge State has no position about recalling the bench warrant.
Okay. I'm going to set aside or recall the bench warrant. You're going to be free to go. Your lawyer is going to waive arraignment for you, meaning enter a plea of not guilty. And you will just need to make sure you don't miss court next time. This is sort of the past that you got. Now I know good address, your lawyer knows how to reach you. So if there's no Mr. LaFavor, next time we've got court, then I'll do another bench warrant and then we'll just hold on to you until we figure out how to resolve your case. Okay?
Yes, sir.
Let me look at your bond order. It is 2 years old today. And we'll figure out if there's anything. You're supposed to be staying away from someone named Kamora Conley. Do you know who that person is?
I know that I had an incident with that person, but I don't know them personally.
Okay, but so that's not someone you're having trouble staying away from. It's
No.
not your sister or a girlfriend you still have feelings for. Okay, good. That's the main condition of your bond, other than you need to show up for court. But you'll do that going forward. Anything else, Ms. Wood?
No, Your Honor, thank you.
Okay, I'll get that warrant set aside and then you just stay in touch with your lawyer, okay?
Yes, sir. Thank you very much.
You're welcome.
You're free to go.
Thank you.
All right, have a good weekend.
And then Franklin King, I'm guessing by process of elimination, it's the guy in the white shirt. Come on up.
Judge, Mr. King is actually a DV case.
Okay.
And so I'm trying to get in touch with Miss Willingham. I believe she's out today. So I'm trying to get in touch with someone from DV.
Okay,
But I wanted to let you know that.
thank you. I'm looking up the case.
to make sure I got that's correct, right?
Mhm.
Okay, I already did it. I just want to double check.
Okay.
Okay. Mr. King, I'm Judge McBurney.
How you doing?
You have a case that was assigned to my division that was indicted just a couple months ago. You were arrested for it 2 years ago, and the allegations are 4 years old.
Yes.
So this is a super old case. Tell me what your address is these days.
The address they had on file was 30.
No. I want to know where you stay now. Like if you were to say, Judge, it was nice meeting you. Come on over for dinner tonight. We're having X. What are you having for dinner tonight? Why you look at her? Why don't you help out?
See the cook.
Okay. What is for dinner tonight?
The salmon.
Ooh, so I'm not a big seafood guy. I'll come over for salad. So if I was coming over for salad, where do I go?
3159 Harris Drive.
Is there an apartment number?
Yes, apartment 4.
Okay, but you recently updated that, or because that's what's in the system.
Yes, Judge, because the system had it as Atlanta, it's actually East Point.
Oh,
So that was the.
you think even though the zip code might be right, that would glitch it? As my kid would say.
Stranger Things. with
Okay.
the USPS.
How long have you lived on Harris Drive?
I've been there for about 3 years now.
Okay.
I had the same issue with child support. I wasn't getting letters from child support. But when I changed it to East Point, I was starting getting like my back pay and stuff, all that stuff.
Okay.
So
Well, we'll fix it. If you don't mind doing an address change form. It sounds like is it 30344?
yes, sir.
So everything's right, except it should say East Point and not Atlanta.
Does it say, it still says Atlanta right now?
It does.
Okay, because I thought I did an address change, but I'll square that away. So yes.
Yeah, the most recent, you may have, it just hasn't hit the docket. The most recent filing was the judicial hold from May. Plea and arraignment was May 28th. You weren't here. I gotta take a warrant out. So that went in late May, and nothing has hit the docket since. So if you do a waiver, assuming that's what your client wants to do, and a change of address, changing it from Atlanta to East Point. But now that we've met and you've given your lawyer all your contact information,
Yes, sir.
does the color mean anything, or it's just on? Okay. It hasn't been an hour yet. You'll need to be here because your lawyer is going to be emailing you and texting you saying, hey, you've got court, and your address could change to Alaska. She still ought to be able to reach you with, there's better salmon there anyway, to do what you need to do and be back here. So this was your, hey, I get it. And we need an entry.
Yes,
Appearance.
and I will get that.
So entry, waiver, change of address.
Yes, Judge.
Whole smorgasbord. All right. Ms. Nix, I know this is not your case because of it. I'm just looking at the indictment. Can you tell me how Cameron Farmer is allegedly connected to you? Kid, girlfriend, mom, complete stranger?
Ex-girlfriend.
Ex-girlfriend.
Mhm.
Okay, then it's a DV case. That prosecutor's not here, but Ms. Nix is a prosecutor, and I'm going to turn to her for her thoughts on whether I should set aside the bench warrant from this case where the allegations date from July of 2020, but weren't indicted until 2024. You're not Ms. Farmer. No, okay, because he's not supposed to be around Ms. Farmer.
Judge, just for the record, the state's going to object to recalling the bench warrant. In the last case, this was just a week later. In this one, it's 3 months. And so based on that, we are going to object to recalling the bench warrant. I don't have any other information for you, Your Honor, though.
Okay, but that's a fair point. Let's work through that. Why now?
Judge, I am assuming when he figured out that he had a warrant, he contacted me earlier this week, and was forthcoming. And quite frankly, I actually use the post office quite often to send letters, and I know that it takes a long time to get stuff different places. So I can believe that the post office didn't catch that glitch in the address.
Okay, I'm not worried about that part. I mean, I worry about it because like we send important things in the mail. And I asked it the wrong way because I'm sure you brought this to us as soon as you heard from Mr. Franklin. So let me ask you, how did you suddenly learn that you were wanted or that you'd been indicted?
My fiance, she was driving my car one night. She got pulled over. I think it was about like a couple of days ago. So I reached out to Miss Woods and stuff.
Did you get arrested?
No.
No.
They actually pulled me over, I think, the day before yesterday night. And they asked who car it was, and I told them that it was my fiance, and they let me know that he had a warrant out. So I contacted him when I got home, and he contacted his bail bondsman, and then he contacted Ms. Woods.
How did you know to reach out to Ms. Wood?
I called the courthouse.
Oh, okay. Hey, I'm King Franklin, and they said you've got a lawyer, or at least this is one of the lawyers assigned to this court. Because
Yes, sir.
Ms. Wood, I don't think would know, or because you hadn't filed an entry. Anyway, you guys connected. I get it. So, what were you pulled over for?
He didn't pull me over for anything. I guess he scanned the tag.
Oh, and it's in Mr. Franklin's name. And so, hey, we've got a warrant for this guy. And so they're going to want to see if he's reasonable to think he'd be in his car. But you were. Okay, lucky day for you. Okay, the lesson from this is you need to stay plugged in with Ms. Wood. Don't miss more court in connection with this case.
Yes,
All right? I will set aside the bench warrant. I understand Ms. Nix's point, but it sounds like you were blissfully unaware that you had been indicted. And I get it, given the age of the charges and the staggering by 2 years of the allegations, then you're arrested, you bond out, and then 2 years later, you're indicted. And frankly, you've kept a stable address. We just need to have it say East Point. But whether it says East Point or Kalamazoo, don't miss court again because your lawyer's going to know and she will be letting you know. Okay. If you haven't heard anything for a couple months, just reach out to her. Say, hey, is everything all right? And everything will be all right. She'll want to see you soon once Ms. Wood, once she gets the discovery from the prosecutor. And then she's going to want to talk and you're going to try to remember what happened 4 years ago. And we'll go from there. All right. Ms. Wood, anything else on behalf of King Franklin?
No, Your Honor, I appreciate it.
Do you have any brothers or sisters?
Yeah, I have a lot.
Do they have similar first names?
Mhm.
No?
I
Okay.
think is it Franklin King or King Franklin? Go ahead.
Franklin King.
Oh, it's backwards. I'm looking at the bond order. Got it. You're Mr. King.
Mhm.
Okay. So your first name's Franklin. Nothing wrong with Franklin. It's just like, okay, that's fine. Standard first name. The judge who gave you a bond flipped it around and like, wow, King. Mr. King, don't miss court again.
Yes, sir.
All right, Ms. Nix, will you please well, it'll hit the docket as well, but if you just shoot Ms. Willingham an email saying there's going to be a waiver filed and so we need to get discovery out.
Yes, sir, will do.
Thank you so much.
Thank you, Judge.
Thanks, everyone.
Should I grab, Ms. Johnson?
Let me just make sure I think we cleared the calendars. Apparently Ms. Rios was done because she's gone. Thank you, Ms. Jackson, for being here. And Officer Evans, you never know when we're going to get a plea off of plea and arraignment. These folks have done it before. I appreciate it. Have an excellent weekend. And I'll be in trial again next week. So it should be pretty quiet for both of you, at least in this courtroom.
Thank you.
Yes, Your Honor. Thank you. Have a great weekend.
All right. Bye-bye. All right. Yes, please bring in Mr. Hirsch and his client. All right, Ms. Rivers, are you ready to pivot back to State versus Tezera? Let's do that. There is another question from the jury. It reads, the time of the 911 calls is missing from our information. Can we know the time of those calls? The time of the 911 calls is missing from our information. Can we know the time of those calls?
Sure.
Unless both sides want to reopen the evidence without argument, the answer is they've got the evidence concerning the time of those calls, good, bad, or ugly. It won't be how I write it, but.
Yeah, I hate to show my, what is the time of the calls? Do you know?
Not off the top of my head.
What?
I said I don't know off the top of my head.
Oh,
To see what the time is. We haven't agreed on anything. I just asked what the time
right.
is.
I don't know that I've ever had a 911 call entered without a CAD report.
Right.
And so sometimes I don't know, I've had a case where it matters quite this much, but it's often relevant just to say this is how quickly were the police there or this or that. Anyway, it's of importance to these folks apparently.
I never got one.
The CAD report. Yeah, I don't remember a CAD report being in evidence, in which case I'm not sure we'll be able to figure out when the call was.
Sometimes it's in the report. That's the only thing I can think of. But
I mean, in Sook's report, that would be remarkable.
stranger things have happened.
Yeah, it might say Philemon was dispatched at X and then the call can't have been too far from time X.
Well, I think that's probably the question is, like if it was an hour before, I think they're probably wondering how much time there was in the apartment for anything to have changed from the incident.
Right. They can triangulate some because both Philemon and Skidmore, I think, testified that they got there quickly. I happened to be in the area and so I showed up, but is that 10 minutes? Is that 2 minutes? I don't think there was testimony to that.
Yeah.
Right. So despite the business record certification saying they provided the CAD reports and the 911 calls, you don't have the CAD reports?
Do not. I think that because we got the business record certification not at the same time as we got the
the 911 calls that Ms. Latner's may have just, used a template or something.
Yeah.
So the incident report has a event start time. Of 22:08.
So one answer is it was before 10:08 PM on June 11th. I want to be clear, I'm fine saying you got to figure it out, but if everyone agrees that they're willing to share that fact, now, police report's not an evidence, but the body cam it's another way you could look at it is what's the earliest timestamp on Philemon or Skidmore?
Your Honor, I think at this time, we don't know, to be honest, so I would just say all the evidence is in. If for some reason that changes and we want to stipulate something, I think we can.
Well, if you can.
You want to look right now.
Ms. Nix is messing with her computer, so I'm guessing she's pulling up either Skidmore or Philemon to see what's the first timestamp on the body cam.
Yeah, but that's not gonna.
I'm not saying we have to do anything, but at least we know the call had to come before then.
Oh, right. But I think their point is how much before? In other words, how much time did Ms. McCall have alone in the apartment?
You're very convinced that you can read their minds.
Officer.
Well, what the relevance is.
This is a jury.
Fair enough.
Maybe if it started at an odd number, guilty. Even number, not guilty.
Well said, Judge.
Officer Philemon's body cam goes back, so it would have been turned on about 22:14. It starts at 22:12 because when they turn it on, it remembers back 2 minutes, but it doesn't have the audio.
Okay.
So her body cam starts at 22:12 and she's driving in the car.
Okay. So the call had to have been, the latter of the two calls have to have been, well, except they were dispatched before them. We heard all this stuff and like, yep, we've dispatched someone because is it DeKalb? Is it Atlanta? Yeah, I think the answer is they've got the evidence that they've got about the time of the call. It's not going to make them happy, but that's what they've got. Okay, let me craft some language and see if it meets with your approval. What to add? Okay. Perfect. So again, the question was, can we know the time of those calls? My answer is you must rely on the evidence you have to determine, if you can, the time of the calls. That work for you, Ms. Nix?
Yes, sir.
You never like what I write, so you can object, but
I just think, it sounds to me like that's gonna sound, okay, so let's look now, what's the time of the calls where I think we just agreed that they won't be able to find it. So I would just, because of that, I would suggest, all the evidence is before you.
Okay, noted.
Your Honor, are we excused?
Let's wait for Deputy Gordon to come back. Are they good?
Yeah, 5 minute break.
Okay. All right. Then yes, you can be at ease. I've got your numbers, and my guess is around 3:30 we'll be reconvening, but we'll see.
And you said they're taking a 5 minute break? All right, if it's okay with the court, I'm just gonna run to my car and get a charger and come back.
Okay.
Thank you.
How come you don't wear a cool earpiece like that?
Yes, I had it already.
Oh, really? Where are you normally? Oh. Do you have to wear a mask?
Yes. So this is a privilege.
Hey, you're welcome here anytime. Anytime. Surprised you don't have to wear a sash that says Adams. Yes, I'll take you back there. Let me just mute this.
Yeah. Okay. I got you. I got one in my office. When I go back and come back up. No, I saw Adam. He was out. We were coming back in.
Ms. Rivers, are you ready? All right, we're back on the record in State versus Tezera. It is 4:15-ish on Friday. The jury has deliberated all day, a little bit yesterday. They've asked some good questions and they have come back with, remember what number we're on, but another question. It's actually a statement. It is 4 words. It says, "We are still split." Ms. Nix, what is your recommended course of action?
Judge, I think our recommendation is that we bring the jury out and poll them. And then,
Poll them.
At the end, I mean, Judge, if they can't, I apologize. If they can't come to a resolution, we understand it.
Okay. I'm going to interpret your request as I bring the foreperson out and ask him or her not what the division is, despite Mr. Hirsch asking for that earlier, but asking that person if there are good faith deliberations, but there is an impasse that does not appear to be capable of being overcome. Words to that effect.
Correct.
Okay. Mr. Hirsch, your recommended plan of action.
I have no objection to that.
TGIF, could you please have the foreperson come out? Good afternoon. Are you the foreperson?
I am.
Thank you for serving as the foreperson. It is my understanding that the jury is divided.
Yes.
And by divided, I mean, and I don't want you to tell me any numerical division, but there are some jurors who believe the case should be decided in one way, and there's some jurors who have the opposite view, and there may even be some in the middle, but there's not a group of 12, which you need at one end or the other of the equation you need to solve.
Correct.
Is it your sense that the jurors have been deliberating in good faith throughout the day?
Yes.
And it is a good faith disagreement as to whether the state has met its burden.
Yes.
Okay. Do you have any concern that there are jurors who are refusing to deliberate and don't want to participate in discussions? I don't mean that they disagree, but that they're effectively sitting in the corner with their back turned and they refuse to engage in any discussion about the evidence, conflicts in the evidence, or lack of evidence?
No.
Okay. That's very helpful. I appreciate that.
We also have another question.
Okay. We'll receive that question in just a moment. Thank you. I hope it's not about the timing of the 911 calls. I'm out of answers.
Give us until Monday, and I've already.
I'm gonna do that this week. This week. Thank you. The question is, what is the time of the alleged crime of drug trafficking? What is the time of the alleged crime of drug trafficking? There's more on the card. It's not a question. It says, page 7 of the charge, within possession, actual and constructive, sole and joint. So the question is, and it's in a different set of handwriting. I'll share the card with you in a minute, but what is the time of the alleged crime of drug trafficking? And then there's this reference, page 7 of the charge, within possession, actual and constructive, sole and joint. Deputy Gordon, would you mind circulating this card with lawyers? Thank you. State thoughts?
I am pulling up the.
All right, while you pull up, Mr. Hirsch, thoughts?
What is the time of the alleged charge?
The same time as the 911 call?
Yes. I think that, you have all the evidence before them. I'm not really, I don't think I've ever had a question like that before, but, I don't really have any thoughts other than you have the evidence before you, or you have the charging document before you. All I noticed, judges, alleged was underlined. Do we need to know anything more than that?
Ms. Nix?
I think that that's a question of fact that they have to make a determination about.
I'm reading it differently. And so I guess I'm struggling in a different way. I think they are legally confused right now. Because possession is an ongoing offense. Let's say that the way this case had played out is that there was a tip that a guy with a multicolored backpack and a Publix bag and a green duffel bag had a trafficking quantity of cocaine. And they film him for a half hour waiting until he does something suspicious. There's a hand-to-hand transaction and they take him down. He was trafficking that whole time. We don't look at it as the shooting was at 10:52, where there is a precise occurrence. As long as you think of the three elements, possessing 200 or more grams of cocaine of 10% purity or more, the person who had that that sealed package might have possessed it for 10 years. And that person would have been trafficking for all 10 years. So I don't know that it's so much of a factual finding as the possession piece is. I feel like the answer is drug trafficking occurs whenever someone possesses 200 grams or more of cocaine with a purity of 10% or more. I think that's the correct answer and the one that will lift a little bit of this veil of confusion off their eyes, because it's not 10:15 is when drug trafficking occurred. The time on the clock is immaterial. It's did someone possess it or not? And the moment they possess it, and as long as they possess it, that crime is continuing. 10:15, 10:16, 10:17, on to the next day. If you put it in a storage locker and forget about it for 4 years, you've trafficked for 4 years. You could charge any day in those 4 years if the statute of limitations allowed it.
Yes, sir. And I see where that comes from. I think that is because of the way that the chart, the instructions are written. So I understand that. So I would support giving that answer of whenever you feel he possessed it, or whenever you feel the person possessed it.
Yeah, I'm not going to say you feel he, but the crime occurs when the possession occurs. Mr. Hirsch, that's not what you asked for. Thoughts about my proposal?
Well, Your Honor, you're right that it could happen any of those times, but that's not what I prepared for. I prepared for what was charged in the indictment, which was June 11th, 2021. So I think at the most, I would say at the time alleged in the indictment.
Okay, that's a fair point. Because if for whatever weird reason, they thought, well, you know what, on June 8th, we think he had the drugs. That's not what's alleged here. I don't know. All right. I don't know that the date is material in this case. It's not that kind of charge. But let me think about some language. I'm not going to write it on the card yet, because this is a different question.
Like I can see nothing. Because possession is the crime. But the way that you
How about, Ms. Nix, trafficking in cocaine occurs whenever a defendant possesses 200 grams or more of cocaine of a purity of 10% or more.
I think that the confusion that they're having is in the way that the charges or the instructions are written, is that possession means that at the time of the alleged crime. And I think that they're confused about what the time of the alleged crime is, because it's not connecting that possession is the crime.
Got it. Hence their reference to the jury charge on the card.
Yes.
Okay.
So I don't know, something like,
Hold on. Trafficking in cocaine occurs whenever a defendant possesses 200 grams or more of cocaine of a purity of 10% or more. It is alleged in this case that that possession occurred sometime on June 11th, 2021. The exact time is not a material allegation.
yes, sir.
What's wrong with that, Mr. Hirsch?
I have no objection to it.
Okay, that's a lot of words, and so I'm going to print it out and staple it to the card.
Thank you, Judge.
That's right. June 11th is also an indictment. It's June 11th.
Yeah, I want to make sure I got the right date. Is it June 11th? Well, I got the indictment. No, I don't have the indictment anymore. They took it away from me.
Actually, didn't bring this file with me, but I've got the case up here.
Oh, I can look it up. 23, let's see. But thank you for, we ought to double check. Last thing we wanted then is the next question. Why June 11th? What? Indictment.
Yes, June 11th,
Yep.
2021.
Yes, we agree. We ever had to print something in the middle of an active shooter thing, it would be bad news. This takes forever. You'd be saying, get out of here. I'm like, the printer, it's not done. One page is like 3 lines.
Well, hopefully there will not be another active shooter situation in the courthouse.
That's some years ago, man.
Yeah, that's why I said another.
I'm saying, like, I never happened. I was like, 12, 13.
There's a memorial downstairs.
Thank you.
Next. So, do we have to take a moment, or are we just waiting?
I'm gonna sit tight, just, you are free to one of you should stay nearby.
We wanted to have a chat with Attorney Hirsch.
You should step right outside. That's fine. I'll mute the microphone, but step outside.
Thanks.
I think you can, well, yeah, I just step outside. I think both jurors are in a different space, but that's got that annoying lock on it. Ms. Rivers, you ready? All right, we are back on the record in State versus Tezera, and in a different set of handwriting, the jury has indicated, and I quote, "We still can't come to a agreement, and we need to leave at 5." They had, I believe, adequate time to digest the response to the question of what time is it alleged that the crime of trafficking occurred? Having digested that, the result is that they remain divided. The foreperson came out and answered my questions about the nature of the division, that it was thoughtful and based on discussions and disagreement, that there were no jurors who were refusing to participate, but that in her opinion and the opinion of her colleagues, it was an unbridgeable divide between those who were leaning or who had come down on one side of the guilt, not guilty, guilty, not guilty divide, and those who were on the other. And there might have been some in the middle, but the point was, after hours and hours of deliberations, they saw no path forward to a unanimous verdict. And so I intend to declare a mistrial. Ms. Nix, anything you want to get on the record concerning that proposed ruling?
No, sir.
Okay, Mr. Hirsch?
Judge, I'm on a roll with you. This will be 3 in a row where I'm in agreement.
Okay.
No objection.
All right, and I want to be clear from this ruling, and I'll enter an order to that effect. This mistrial is being declared because of the impasse of the jurors, not because of anything the state's done, certainly not because of anything the defense has done, but I'm emphasizing that the state did because it's not a mistrial that is prompted or caused or promoted by anything the state did in the course of these proceedings. It is solely driven by this jury's inability to reach a unanimous verdict of guilty or not guilty. They are hopelessly deadlocked, and we need not prolong their agony. So I propose to bring them out so that I can thank them in front of you all. Some of them may want to stay and give you feedback. Clearly, some of them need to leave soon, but I will discharge them in a moment. Ms. Nix, anything before the jurors come out?
Just very briefly, Your Honor. What would you do with the actual drugs themselves? Will we take them back?
You will keep them. They remain state's evidence.
Wonderful.
In fact, all the exhibits will be returned to the respective parties. Ms. Rivers will not be generating a transcript of this trial unless and until a lawyer says, if there's a retrial, I need Skidmore's testimony or I need X. But we don't prioritize generating transcripts of mistrials. And we certainly return the evidence because there's no record to be transmitted to any appellate court.
Understood.
So anything with a defense purloined sticker goes back to Mr. Hirsch, and anything with the state's prosecution sticker goes back to you all, especially the drugs.
Understood. So my understanding is that if the state were to retry this, we would ask for something specific or just the entirety of the record itself, or
we would have a conversation because the usual demand is we need the trial transcript, and Ms. Rivers will be in the middle of transcribing a trial in which someone likely got a life sentence and was needing that transcript. That's not a no answer to you all, but you would need to help me understand why you need everything, why you would need openings.
would you have an idea?
Sounds like
which trial count?
It won't be September.
Understood, Judge.
All right. Okay. With that, let's bring the jurors in, please.
All right, for the jury. All judges present, count for.
Thank you, Deputy. Everyone can be seated. Ladies and gentlemen, I want to thank you on behalf of the state, on behalf of Mr. Tezera and his legal team for your dedicated service, an entire week for what I was told I could safely forecast to you would be 3 days. I have no doubt, and your foreperson confirmed it, that you entered into those deliberations with an open mind, discussed the evidence, the conflicts of the evidence, and absence of evidence in a healthy back and forth way. There were no jurors who refused to deliberate, meaning sat in the corner with their back turned and wouldn't listen. But this is a case where it wasn't possible for this group of 12 to reach a unanimous decision of guilty or not guilty. I understand that. It happens from time to time. It is not a failing on anyone's part. It's how this process is supposed to work. It is going to be a message to the state about the case. It's going to be a message to the defense about the case. But not every trial results in a unanimous jury. So on behalf of everyone involved, thank you for your time. I'm going to have you go back into the jury room. We've got letters to give you that are proof of your service in case someone's been saying, where the heck have you been? I just want to thank you personally. I know some of you need to leave 2 minutes ago. You'll be able to run out the door after you get your letter, but I can also answer any questions you have. I have a couple questions for you about the new video system in there. And then for those of you who want to stay, I am confident the lawyers would like to get feedback on what worked and didn't work, but that's optional. And I'm not going to tell them, oh, they said no wages. Those of you who want to stay, you'll be able to come back in the jury box and interact with the lawyers. But we'll talk shortly. I know time is short. I'll see you in the jury room in just a minute. Thank you.
All right, for the jury.
Next week. Mr. Tezera, you remain on bond, and so all the conditions of your bond continue to apply. It's not going to feel this way, but it's like the trial never happened. You're back in a posture of you face a charge of trafficking in cocaine. You've got a lawyer. He's going to continue to advocate on your behalf. I'll put this case on an upcoming trial calendar. It would be October at the earliest. And the two sides will continue to talk. One outcome would be we try the case again. Another would be you all come up with a way to resolve it. I'm not applying pressure in one way or the other, but we do need to resolve the case. It's not getting any newer. So I'll keep you all posted on scheduling. You keep me posted on what's happening from there. In case I don't come back out here, I want to thank the lawyers on both sides for a fairly and evenly keeled tried case. Everyone got along well, behaved professionally, and that's all I can ask for. And that's what the jurors are entitled to. So enjoy your weekend. And I won't see a lot of you next week because your case isn't going out on Tuesday. But if anyone needs me, we'll be in trial again on Tuesday. Thank you, everyone.
Thank you.
Welcome.
Not like the second.
I mean.
Monday.
Yeah.
But the defense stuff.
I'm gonna give it back to you.
So like that.
I'm gonna get all of everybody gonna get this stuff back. I got enough stuff back there.
If you want to regroup with me today, you can, walk with me if they want to write it down. We can just regroup it on Thursday. So, do you want to? Yeah, probably close. It may be a minute.
That's all our pictures.
Yeah, I'm gonna be.
See you next time. All right, bro. Be here in October. Good, right?
Birthday.
Got someone. Got someone. Next week. Test. Got someone on Monday.
You know, the truth, I made like, when I was in the home patrol, I made pretty much for cases. When I was on a school teacher, I was not one of the bags that I ever had tested came back positive for suicide. Really? They were clearly mushroom, they were clearly packaged, and every time I came back. So we had to come to you know, we should catch kids out fast, just trying to do them. Of course, nowadays they got growing labs and all that.
One of those instances is a host group, and she, one of the roommates actually. And you're not intending to, you know.
Why would you get this?
You
got
course lined up. Yeah, but like if you go out there and you like pick it up, and then it becomes intent, you know.
Sure.
But, you know, yeah, I'm great responsibility.
They have it all over the place.
We love that for us. That trial next week, y'all, should go pretty fast. Ready for homicide.
Yeah, don't believe him, because he said we'd be done by Tuesday.
Hey,
I don't believe you guys.
listen, how fast you think me down the body would do that trial? We did.
It would be today, the same amount.
No. 14 minutes a day.
Yes, we do.
Oh, wow.
He wouldn't let,
84 witness trial.
he wouldn't let Foster go home, because he kept saying, no, we're gonna get to him, no, we're gonna get to him.
I thought we would, I thought we would go with.
And he wanted to go get his like personal car, because he had only brought his unit with him.
Oh,
Like
you go with
Thursday,
that?
like 3 o'clock, and I was like, no, we're gonna get you.
But then too, we have got the day.
Oh,
yeah.
yeah.
That is Wednesday.
If we, I think we would have 4 days.
I mean, they still would, we would have been here now, anyway. anyways.
That's
If
true.
we hadn't done that.
What have we been yesterday?
So they would have tried to.
On Skidmore days, we literally only did 2 cops, right? Wednesday.
Yeah, that's bad.
We did Skidmore. We got the Skidmore.
Went too long on skipping, that's just my personal opinion. Haven't done this 41 years.
Not 41?
Yes, 41 years I've been on this
I
dark.
mean, you've seen it all.
I have seen it all.
You've seen it all. You gotta read the book. I've seen it.
That's what they keep telling me.
You do? I did. That was what I seen.
41.
41. I didn't even get alive 41. I'll be 36 and 2. Hey, you gotta say hello.
Yeah, I thought you were
I'm not
like,
sure to see your books.
I thought you were like 38, 39.
Is it great?
No, it is yours, me. Carry yourself.
I could hear you.
Older.
How old is
I probably guess how old Brittany is.
We're here in the late 40s.
Oh,
54, I was 54 Tuesday.
Happy
Yeah, I've been strapped up in the air. You supposed to be like, I ain't coming. You were supposed to say, I ain't coming, I'll go see you. Happy belated, man. What you gonna do, man? And then you going straight into the trial next week. You said what?
I should have known when you said teacher.
Mm-hmm.
They usually start out.
Yeah, that is true. It's bad. They fine, bro.
I mean, I always do.
Are you? I thought we were gonna say that. Hello. Sorry, it wasn't like.
I saw, one of the first times I met her office, I saw some pictures of like some little kids. I was like, oh, your kids? She's like, my grandkids. I'm like,
Really?
oh my, your grandkids? You got kids here, 15-year-olds?
I can sure you come in through here or throughout that.
Interesting.
Oh, okay. They're gonna come through this way? You like here for the defense, so I'm waiting for. Oh, okay. She said, Ms. River said it's everywhere, so I guess we'll work. All right.
21, 22, 23.
How was your room?
12, 10, 9, 8, wait, 12, 10, 9, and almost 6. And then there's a almost 1-year-old. Should be 1 this month. There's 4 girls and 1 girl. I'm just aging back. I'm Benjamin Button. I'm just 2 years younger than you.
My parents, 6.
My mother's 74.
As I should have.
Wow, something like that.
That's what I'm saying, I'm gonna talk to her, see what she say. She would love that. That bill.
That's hard.
You know, I said that about my dogs.
Yeah.
They're not entertaining.
My son was up this morning, it was 5 something. I'm walking around getting ready, he's up, I was like, go lay back down, go lay back down. No, I wanna stay right here.
How old is it?
I wanna stay with you.
Okay, so John.
They had a problem with that, only 13 seconds left. Maybe
We got time. Nothing but time. I'm excited, very excited. I guess I was working on the child station.
It can be together.
I'm working on
Big time back there.
One day. On a contract, that's what I said. It's always good.
it's hard to look at this one specifically is awful, but in this case specifically, the mother as an adult daughter, she has two young children, a 6 and 7-year-old. The adult daughter's boyfriend moves in, everybody moves in. 12 people in a 2-bedroom apartment. What's the boyfriend starts to less than 2 children. And
The brother and sister.
like it's awful, awful. Makes them together. It's awful.
No.
And then mama's cousin, around the same time living in there, he's also molested. So.
It's bad.
uh,
So the cousin and the boyfriend were they
No,
friends? Did they run across each other?
No, they didn't know about each other doing this, but what's crazy is that my case is involved. So they find out about both of them because of what's in. The children are telling about one guy, both, and then within their, while they're telling, they start talking about the other. So the other guy, the cousin, his case is in Judge Cox, he took a plea immediately. So we talked to him with his lawyer, and we're like, hey, did you know that this was going on? He's like, no, but the boyfriend had tried to have sex with me.
I was like, God.
I said, what? He says, yeah, he came over to text me. Well, I was like, it's going to like a good text. I was like, yeah, he texted me. So, I was talking with my investigator, my guy, my defendant's lawyer. Their client, so the big man was getting. And so, this way.
So why did they take them off?
Because they have the, so remember.
Oh, that how sick this was.
Okay, take one out. Tell the big one.
Coming back. Okay.
No, it's not Tim Cook, it's Derek.
Okay, try these cases. So he's on.
But no, that, I'm putting that together. It said you get it. They're cute. I don't know what to say. I said, I don't know what to say.
Max is there. Emmanuel leaves. David. Emmanuel.
Yeah.
I thought I was going.
That means it's all you. I've been saying that for so long.
But you know, you hear the better. You know, you can hear the lyrics a lot better.
Oh.
They're not made for a person.
Are they? Is that what
I
they?
think so, because when I'm home, you could whisper and I can hear you.
Oh, you can hear everybody talking?
I hear everything so clear.
Really? I gotta watch what I'm saying.
No, so.
Yeah, you do. When you're just at the table and your mic is on, it's crystal clear.
But even if it's not on, this one appears pretty sensitive.
It picks it up. I can hear it from here, but I can still make out what you're saying.
Oh.
Not as clear.
So are these, were these put in for, okay,
They were put in.
I was thinking that because like.
But they came in when they was doing this new courtroom setup. And I was telling them, then these microphones, can you turn the volume up, they're not loud. And I'm sitting right there. That's why I like to do remote, because it's so clear. And it comes in crystal clear on YouTube.
but we all in here think that, that's why the people keep saying, can you speak up, because it's not really projected.
Yeah, well, I didn't know if they were like the same volume, and it's just that, you know, especially lawyers are talking to these and we have our court voices, you know.
I imagine sometimes when the air is on, you can't hear it.
Yeah. Oh, then you have, you know, you have all the other sounds and or things, so and all that stuff, but. And then you have all these monitors blocking everything too, so.
That's where we were from.
You know,
I think that's. And where were you from? I did where exactly? Georgia.
Litchfield and Well. He's from Litchfield and Well.
Where are you from?
Originally from Michigan, but I've been out here almost since I was 14.
In front of that.
When I'm a thing.
And then.
I didn't sit out from Atlanta to.
I don't know. Was it how long did it?
21.
How long?
Oh, you can't do it. I just can't. This is a big fake. You can't talk about it.
I may have thought that you were from here. I could see it. Just, I just have sound. Feel something. What about you?
Just don't want to walk through that.
No,
It ain't now.
oh. Cause we live in like,
That's now. I used to live down there. My kids went to, what's the name of that school right around the corner? I heard.
that's a really good school.
It is. My kids went there.
It's a really good school.
It is.
It's good, we split.
Decatur used to be so ghetto.
Really?
It is.
Out of nowhere. Cause down the street from Southwest Decatur High School, $500,000 townhouse.
I had nothing.
Oh,
Oh,
That's what it used to be there.
I remember when I was a little kid, I had gone to hang out with my cousins. I go hang out with my cousins, and they had all these, what's it live down here? Oh, very great.
Hey, there are a few jurors who are gonna come out. Yes, if you wait right there, I'll get it.
For like 2 minutes.
Oh, you coming? Okay, are you gonna be with this one? Give me out of those screens.
I will get back to Aiken. So that they can put it back in, back in evidence and maintain. That way there's no custody, I mean, chain of custody.
And, yeah, the penalty is you just usually with something in front of you.
So I get, where they are. We'll go through it. Monday, and then, Tuesday, and then we. Unless they have a different process.
Yeah, we're adding it. You can knock off now. We're more.
We're until like, what was the split?
You don't say anything else.
That's what the split was.
10-2 to what?
It finished 11-1.
It started 5, 5, and 2.
So y'all were 11 not guilty, 1 guilty.
Yeah.
Okay. Y'all started. Say it again.
We started 5-5-2. All right. Really not. This is so nice for me, because I knew what we got from where they were. And, can you just figure something out that I think I had to do? Which isn't extraordinary, because when I do like have a trial, every time I watch a video, read the third or fourth time, or read, I do like. Hey, no closing arguments. No, I was actually complimenting you. Good questions. All right. So, when you guys picked something out, I didn't realize that, when Nigel got into the apartment, he didn't have it first, and later he did, and when that question was asked, I was like, oh my God, wow. But I really like the jury questions because. I'm okay.
I just want to share with them, if you haven't already, the ultimate vote on that, because that's going to see. You already told them.
Catalog. And also, I usually try to suspend jurisdiction for a little group. It's more versatile. When I'm having like, but last time I was questions out, not really questions good for me, although you can't have that much in the questions, but I was spending a lot of time. I was in the right. Yeah, if I could have taken the impact, so that's a good question for me, and I can tell you about that. And two, is that if I was constructive possession, is that not guilty? The answer being no makes me think, oh, I think constructive possession. So, but again, I know that you can't put too much questions early on, but those two have been spinning. If you have, I'm gonna go. If you guys have any questions for me about any of that stuff, let me know.
All right, you got my
I'm going to answer the ring now.
Yes.
I mean, I have also peanut power and stuff. Ring is probably a little different in that, like I don't actually like let's say I want to subpoena something from Facebook, or and this is probably true for them too, but it's almost really hard to get something from Facebook. But again, like, you know, the defense isn't invited to the crime scene. He had a defender fairly early on, and he hired me a few months ago. So 3 years later, obviously, I can't get it. But to the extent I can, I'm really depending on her, right? So.
And so are we, like.
Oh, yeah, so are they.
Most of the time, if something, so officers, especially in Atlanta,